This week on No Fear or Favor, we look at a bill that looks to ensure efficient and fair trials by removing barriers that prevent county attorneys from obtaining police discipline data that they're required to share with defense attorneys. Hello, I'm Jamel Lundy, the Intergovernmental Relations Manager for the Hennepin County Attorney's Office, fancy word for lobbyists. I served in Minnesota House of Representatives for almost 10 years. Hennepin County is the largest county in the state of Minnesota, and the Hennepin County Attorney's Office handles almost half of the state's criminal prosecutions. Follow me as I follow the action at the Capitol with No Fear or Favor. This week's episode of No Fear or Favor is going to be a little different than our usual presentation. We're going to be looking at a bill that has not received a hearing yet, but urgently need one to address the issue of trial delays that we're seeing resulting from a Data Practices Act that prevents prosecutors from obtaining the evidence that they are required to share with defense attorneys related to police discipline data. Brady Giglio can admittedly be a complicated topic, but at its core, it's about a requirement placed on prosecutors by the Supreme Court to ensure that there are fair trials. The first person I reached out to for help with understanding this bill, however, is Claire Deagle. Our office's professional standards director and a state expert who trained the Minnesota County Attorneys Association on Brady Giglio and wrote our new policy on Brady Giglio. What is a Brady Giglio obligation?
It is a constitutional obligation put on prosecutors to disclose to the defense information that is favorable and could affect the outcome of their case.
Why is honoring this Brady Giglio obligation so important?
It's important because we want the defendant to have a fair trial. When defendants have fair trials, that means that people aren't wrongfully convicted, and it means that if there are convictions, they're not overturned on appeal.
To help us break down this extremely important but sometimes very complicated topic, we reached out to Hannah from the Minnesota Association of Criminal Defense Lawyers and Andrew from the Great North Innocence Project.
Brady Giglio obligation stems from a United States Supreme Court case in 1963 where favorable evidence to a criminal defendant in a first-degree murder case was suppressed by the prosecution. So in that case, they decided that in order to ensure that defendants' right to a fair trial, they would grant a mistrial because this evidence was suppressed. And so that created this new standard and new obligation that falls on prosecutors and anybody who is working within their authority, which includes police officers.
Prosecutors play a special role in our system. They're not like private litigants. You know, the court speaks of them as ministers of justice. In order for a defendant to have due process of law, they got to have all the evidence that might help them fully defend themselves. So if you got important witnesses and there's evidence that shows that they might not be that credible, that kind of evidence too has to be turned over to the defense.
So how do we handle our Brady Giglio obligation related to law enforcement?
When County Attorney Moriarty came into office, she took a look at the past practices from the prior administration. And one really important piece that we were looking at was the Minnesota Department of Human Rights, who did a report about the patterns and practices of racial policing in Minneapolis. In that report, the Minnesota Department of Human Rights specifically called out the Hennepin County Attorney's Office process as a systematic failure. And it was very specific to information related to officer credibility and how that information might be public information or also what's called non-public information. Judges in the 4th Judicial District, as well as the Minnesota Department of Human Rights, had said to the office that we needed to be reviewing non-public data to ensure that we were complying with our Brady Giglio policy. So we really focused on that piece of it and worked with law enforcement agencies. We have over 35 in Hennepin County to craft a process that was going to allow us to review non-public data in a way that protected the officer's privacy and also complied with the law.
Is prior to Mary coming up with the process that she has and giving us the confidence that we're actually complying with the Brady requirements, I did not have that confidence, and that was the concern that I expressed numerous times, that I don't believe that we were complying in a way that was effective in preventing us from losing cases. And this is absolutely the right move. And at the moment, I have way more confidence that we are compliant.
How has this impacted cases?
For Brady-Giglio purposes, we know that the defendant is getting a fair trial, and if there is going to be a conviction in a case, it's not going to be overturned on appeal for a Brady violation. But it also is having an effect of creating a large burden for the courts and the agencies. And the reason for that is because anytime we seek access to non-public data, we have to go to the courts for an order, either an order to produce the information to us to review, or an order that the information would go to the court to review. We have filed over 125 of these requests. We know it's working, but it is creating a lot of work for the courts, as well as the agencies, who are then responding to the court orders to provide the information to us.
Is there anything we can do to stop the delays?
The Minnesota Government Data Practices Act does not allow us to go straight to the agencies and have them share the information with us directly. So a change to the Minnesota Government Data Practices Act that would allow that data sharing of information between law enforcement agencies and prosecutors would streamline the process and ensure we have fewer, if any, delays.
So how does this bill help with the trial delays that we're seeing in the 4th Judicial District?
Very simply, it removes the barriers in the Minnesota Government Data Practices Act.
What this bill does is it takes the court out of it. It does not require prosecutors to get a court order in order to get this information that they are obligated to get, and that us as defense counsel and a criminal defendant has a constitutional right to.
So what we've heard in trying to move the bill is that there are some parties, particularly from law enforcement, who have some concerns. I wanted to see if you've heard about any of those concerns and can you give us any information about them?
Yeah, I think, there's some concerns in amongst law enforcement that, hey, I don't want my personnel file to be kind of turned over and could be distributed more broadly, especially if we're talking about things where they feel like, the claims against them weren't necessarily vindicated. The important thing to note is this bill has protections in place to avoid that, to make sure that the information is only being used for a narrow purpose. It's going to be subject to a protective order, so it can't be distributed out to the public. The bill really takes those concerns seriously and makes sure officers' privacy is being adequately protected, in addition to making sure that defendants' constitutional rights are vindicated.
The data still maintains its private data status, but we have an easier way and a more efficient way to get access to the information that the Constitution allows us to have.
One of the big risk factors for wrongful convictions is the failure to turn over this kind of evidence. So it's a really big issue and really important to protecting people's constitutional rights.
If you'd like more information on Senate File 4411 brought by Chair Latz or House File 4244 brought by Representative Frazier, check out the link below. But until next time, this has been No Fear or Favor.